Greetings, Attorney Derek DeBrosse, coming to you from Columbus, Ohio, Munitions Group, Munitions Law Group, munitionsgroup.com, based out of Columbus, Ohio, Louisville, Kentucky, as well as Atlanta, Georgia. We have affiliate attorneys all over the country. Anything regarding firearms or the industry, we can help you. Please give us a call, shoot us an email. As always, be sure to like us, follow us on social media. Go ahead and click that notification bell down there too, so you guys get notifications when new videos pops up. I try to get these out as frequently as I can. I'm trying to be more consistent with that, but as all attorneys are, we're just busy, so I apologize for that. Today we're going to try and finish up the questions from my last viewer question session from the last video. He had asked several questions, and I'm going to try and get through the rest of those today. So with that said, let me jump right in. And the question is when is it lawful to use the handgun in a life-threatening situation when I do not possess a concealed handgun license? Same for home defense, altercation in a parking lot, with the gun safeguarded as in question 2. So he's referring to whether or not it's in the car carried properly. So the question, the crux of the question really has no bearing on how the gun's carried. Your question is when is it okay to use deadly force self-defense in Ohio? And in Ohio, as of, I want to say, Adam, was it April or March? Do you know? April or March, I can't remember, beginning of the month. I think it was April 6th, if I remember correctly. Stand your ground passed in the state of Ohio. So you no longer have a duty to retreat as long as you're in a place you're lawfully allowed to be, and the jury cannot consider your failure to retreat in their deliberation. So we do have full stand your ground now. That doesn't mean you can go out and just kill somebody. You still have to meet the required elements of deadly force self-defense. You know, you didn't pick the fight. And the biggest meat and potatoes part of the analysis, that you have an honest and reasonable belief of an immediate or imminent fear of death or great or serious bodily harm. So that's the best I can do to answer that question. I hope that gives you at least, again, some direction. The Attorney General's Handbook, by the way, on concealed carry addresses that very thoroughly. All right, moving on to your next question then. When is it, is there ammunition for self-defense that should not be used from a legal perspective, hollow points, tumble upon impacts, etc.? I've tried to address this question in a general sense in the past. There's a lot of people out there that'll say, oh, don't load your own ammunition, don't use hollow points. Look, at the end of the day, I've talked to my prosecutor friends. It's generally not an issue. I can't promise you the prosecutor, if they're trying to charge you with a crime, won't bring it up, but I don't see how it's relevant if you're arguing self-defense. They might try to say that you were intending on doing this and you had malice aforethought. Maybe they can get it in, maybe they can't get it in. Your question's extremely broad though. It's more of the type of situation where I need more information on what specific type of round you're referring to. I'll tell you, I would generally not advise you buying the zombie rounds. They have like a zombie on the front of the box and all that. Again, I don't even know if that comes in evidence in a jury. I would sure as heck object if I was defense counsel that it's not relevant. It's merely being introduced to inflame the jury's motions, etc., etc. But from a legal perspective, at least in the state of Ohio, I don't see that if you're using self-defense ammo that is generally described as hollow point, how that makes any difference of whether or not you were in an honest and reasonable belief that you were going to die and you would use whatever tools necessary. I mean, deadly force self-defense is exactly that. It's designed when you use that force to kill somebody. So there's no negating that. So generally I don't have a problem with you using traditional self-defense ammo, but when you start getting into weird, crazy, exotic things, it's not necessarily a legal issue, but more of a factual issue. It's just not a sellable image that we can sell to a jury all the time. It's much like my older video of do not carry a pink gun that had over 500,000 views. I encourage you guys, if you haven't seen it, to watch it. It's not illegal to carry a pink gun, but is it something I want to show a jury? And that's really the analysis that I get to on that question. So I hope that gave you some direction. And I believe there is one or two more here. Let's see. This is a good one. Is there any legal issues with allowing a fellow shooter to borrow, try, and shoot my gun or ammunition at the shooting range? As of today, no. We don't have universal background checks in the state of Ohio. Some states like Washington State, I think you have to do a background check for even transfers like giving your friend the gun to borrow. Don't quote me on that, but I think there's some laws like that out west. But in the state of Ohio, no. So if you're at the range with me and I want to hand you my gun, I can do that. There is obviously some risk if that friend goes and misuses that gun on themselves or another person. You know, they could try to claim that you have some liability there. I think it'd be very hard to prove that and make you liable. But obviously, anytime you give a dangerous item to somebody else, you want to know that they're not a felon, that they're not dishonorably discharged from the military, et cetera, because you can't recklessly, transfer a gun to somebody that you know is a disabled person. That is, in fact, a crime in Ohio. So what does recklessly means? It means you disregard a known risk, right? So if you're disregarding a known risk because you know your buddy was in jail, but you didn't ask him what he was in jail for, you could be potentially held criminally liable for handing that gun to him if he's caught with it. So I hope that answers some of that issue, at least addresses your question there. And then lastly, it says define a gun trust, but I'm not sure what it is and what it's used for. So there's no definition for it. What we mean when we say gun trust traditionally in the industry is a trust designed to hold National Firearms Act regulated weapons. The reason really is there's multiple reasons, but there's three main reasons. One, you keep them out of the probate court system so they're not just sold out from your family when you die. Two, you can have multiple users on the trust, so you can have more than one. And then number three, it allows for more of immediate disposition of the guns after death, so you're not waiting on probate court to approve everything. Highly recommended if you're going to be buying NFA guns. We do offer other types of gun trusts that are more for collectors to preserve the integrity of their collection, and it's more of a traditional estate planning tool. But call us if you have any other questions on that. So I know there's a lot of information, there's a lot of questions. I hope I got them all. If I'm not, just please drop another comment in the comment section. Again, like us, follow us on social media, and please click the bell so you get notifications on YouTube. And as always, remember to be safe out there and carry on.